Hey everybody, welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel, like we are each and every Thursday night, where we do this live Q&A where we talk about all things debt related. Whether you're dealing with bankruptcy, wage garnishment, debt collection lawsuits, all those other horrible things, we go over some different options as far as help you to put a plan, get that thing in the rearview mirror, and move on with life. So again, my name is John Skiba. I'm founder of the Consumer Warrior YouTube channel. I'm also a practicing attorney in the state of Arizona, where I do consumer bankruptcy and I help people who are dealing with debt collection lawsuits, wage garnishment, all that kind of stuff. And my weekly disclaimer, while I am a licensed attorney, if you're trying to get your legal information and legal advice off YouTube, buyer beware. Don't take this as legal advice. You need to find an attorney in your particular state. You'll see my information below. You can reach out. If you're in Arizona, I can actually do consultations with you. And if not, I can refer you to some other attorneys I work with throughout the country. So go ahead and check that out. Also, if you're doing a lot of kind of DIY, I guess, do-it-yourself kind of stuff, if you're trying to represent yourself, I have put together some tutorials, and also one of our sponsors of this weekly live stream is SoloSuit. If you're familiar with SoloSuit, there's a link in the section there on YouTube and on Facebook. They offer some really cool tools to help you put together an answer. They even have this really awesome debt settlement product that helps you in, reaching out to the creditor and getting something in place so that you can get rid of the litigation altogether. So go ahead and check out the links to that, the Consumer Warrior University, some of the templates and tutorials. I have templates and tutorials on everything from filing an answer, motions to compel private arbitration, motions to vacate default judgments, specific courses on bankruptcy, dealing with American Express, Capital One, and gosh, there's about 24 of them. So go check those out. So the way that we do this is, if you have a question, and we already have a number of questions, go ahead and put it in the chat section, whether you're on Facebook or they're on YouTube, and I will put it up on the screen and we'll talk about it, and maybe I can give you some tips and strategies as far as what you can do. So, all right, let's see. First on the thing tonight here said, I just received a 1099-C. I got to get up above I think it's called a Chiron. I got to get up above it here. I just received a 1099-C cancellation of debt from the original creditor. A junk debt buyer has put this debt on my credit report. Can I use this 1099 to remove it off of the credit? So the 1099-C is typically what you get when there's been some type of debt forgiveness by the creditor. So if the original creditor send you a 1099-C, that's telling me that they are counting it as not only a loss, but they've forgiven it. It's gone away. And so now if you have a junk debt buyer who's put this on your credit report, I would use that. Because the 1099-C is, so there's a difference between if an original creditor sells it to a junk debt buyer, they can charge it off, but they're not forgiving the debt. They're getting some money in return. So the 1099-C could be something where you could raise a dispute through the credit reporting agency, provide a copy of the 1099-C, which is your proof or your evidence of saying, hey, the original creditor forgave this. I'm having to count it as income on my taxes. So this junk debt buyer, there's something going on there that's maybe not on the up and up. All right. JB says, now that I have filed an answer, we are now in the discovery phase. So would now be appropriate time to submit a request for production. So request for production is part of the written discovery in a debt collection lawsuit. There's really three types. There's a request for admissions, which are really just where you're asking them to say yes, no to certain information. There's interrogatories, which are essentially written questions on any topic. And then the request for production, where you're asking them to produce documents or other types of evidence. So yes, once the answer is filed, you can start pushing out written discovery. They can also send it to you. But now would be the time that you want to do it as far as if you're requesting information. In the Consumer Warrior tutorials, I have one on responding to written discovery. And I even have one on, you propounding discovery upon them, sending it over to them. One thing I always say is to be careful about requesting a lot of information for them. And the reason why is you need to remember that the creditor, the junk debt buyer, whoever it is, the original creditor, they bear the burden of proof of proving all the elements of their case. And they're going to have evidence to do that. If they file this lawsuit and they don't have any documents, if they don't have sufficient evidence, That's, to me, that's always to me, less is better. Less is more when it comes to evidence in junk debt buyer cases. And sometimes they don't have it. And if you file a formal request for reduction, they'll actually have to go back to the original creditor and get it. So I always say, sometimes it is good to send over requests for reductions in certain areas. Other times you need to be careful, because if they don't have it, they can't use it against you, and you're going to be in a better situation overall. A couple questions here by JB. He says, I got served by LBNB last week. I just submitted an answer yesterday using your template, answering the allegations and affirmative defenses. The template made it pretty straightforward. The first thing I did upon receiving the summons was look it up online at the White Tank Justice Court, which is a court here in Arizona, using my name, and was able to see the case. I tried searching today and no results found using my name or case. Is this normal? Perhaps I used a different system. I'm almost certain I use the White Tank Justice Court's website. So that would be unusual. You may, and I should say this. So the Justice Court website, it's just one site. So like you can plug your name in and it'll show it up if it's in any court. So it's not just specific to one court in Arizona. I would call the clerk. I mean, the fact that you received the document, that's what you need to go off of. The fact that the stuff that's online with the courts, it's generally accurate, but it's also a lot of times inaccurate. I can't tell you how many times I file like an answer on behalf of a client, and it takes months for them to update the record to show that I'm the attorney of record on that. So you can't really trust that. It's one of those things you better trust but verify. You better call the court, talk to the clerk and say, hey, here's my case number. Is this still active? Before you do anything as far as ignoring it. So, all right, this one says, I've won 2 cases, one against Absolute Resolutions and Cavalry, both unsuited without prejudice. That was 2 years ago. I used your arbitration motion. They were great. Thanks. Awesome. Great. Maybe there's not a question there. Just saying thank you. I appreciate that. I'm glad that they are helpful. So, all right. Destin says, I live in Arizona, and if I'm filing bankruptcy, shouldn't that mean I don't have to pay creditors anything? So it depends, which is, the famous lawyer answer, it depends. It depends on what chapter of bankruptcy you're filing. It depends on what types of creditors you have. So if you file a Chapter 7 bankruptcy, which is what most people file for bankruptcy, it does eliminate most unsecured debts. These are debts like credit card debts, medical bills, personal loans. Those debts in a Chapter 7 case typically do go away completely, and you don't have to pay them anything. There are certain unsecured type debts that do have that are non-dischargeable, like most student loans. Those are non-dischargeable. Some taxes, alimony, child support, spousal support, those types of things. Those typically you're still going to owe. Secured debts like your house payment, your car payment. If you want to keep your house, if you want to keep your car, you got to keep making the payment. There's no free car. There's no free house in bankruptcy. You have to keep paying on those if you want to keep them. However, if you don't qualify for a Chapter 7, and the reason why you wouldn't qualify is usually based upon the number of people in your household and your income. If you make more than the average household of your size in the state of Arizona, they could force you into a Chapter 13. Chapter 13 requires you pay your disposable income to your creditors over a 3 to 5 year period. And there's a whole formula that goes into it, but that's when you'd have to pay your creditors back some money, is usually if you're in a Chapter 13. So, JB, thank you very much. I appreciate that for supporting the channel today. I really appreciate it. All right, let's see what right here. See what Don has to say. Don says that he recently spoke to an attorney. He told the bankruptcy attorney situation, no job, no car, no house, and only SSI, Social Security income. He told me I don't need to do anything, that I'm judgment proof. And he says, I owe $25,000 to credit cards. I saw it, Don, or $25,000 in credit card debt. Goes on to say, I'm 75 years old. I use the credit cards I should not have. My credit went from 720 to 430. So, I actually, speaking of solo suit, I just did an online video interview with them earlier today. And we were talking about this very topic, about people who are judgment proof. Judgment proof means that even if the creditor gets a judgment, there's not a whole lot they can do. They can't garnish your wages. They can't take money out of your bank account. Maybe they can't lien you. There are certain situations where people are truly judgment proof. I always say that you got to be careful. And you know what, Don, it's good. You went and talked to an attorney, and that's a good first step to make sure. The reason why I say to be careful, because sometimes you may be judgment proof today, but 5 years from now, you may not be. And so if your situation is not going to change, it sounds like, Don, you're 75, you're probably retired. Your income is exempt. It's protected. The Social Security income, they can't garnish that. Maybe your situation is something where you're judgment proof. But let's say if your situation was different. Let's say that you were on maybe like a temporary Social Security disability or something, and you were 25 years old. Then that situation, if someone was in that situation, it would be different, because they may not be able to collect today, but judgments are typically good for a long period of time. Like judgments in Arizona, civil judgments are good for 10 years, and then they can be renewed every 10 years for the rest of your life. So if a 26-year-old comes into my office and says, hey, I'm judgment proof, we still go over everything, but I want to make sure that, they might not be able to collect today, but what about 5 years or 10 years or 20 years from now? Is your situation going to be any different? That would make that, that analysis change. So, but sometimes, and I've given that advice to people who call into my office, say, look, here's all the facts of my situation. What do you do? And I always say, look, you could file for bankruptcy and get rid of it, or maybe you should do nothing. Because, there's some risk. You're still going to deal with collections, and kind of, Don, like you were showing there, it's going to impact your credit score. But maybe at the end of the day, you don't need to file bankruptcy because it's not something where they can actually collect anything from you. Now, I had a couple comments from the channel that I wanted to go over. This person said, this was a debt collection lawsuit question, said, do I still have to write a written response to the court, even if I'm hiring a lawyer, because I'm waiting on their response about what I should do next? I'll tell you this, if that deadline is coming up, it's always better to be safe than sorry. But if you've hired a lawyer, just call them up and say, hey, are you going to file that answer? I know that attorneys work differently than most people. Our lives are one never-ending term paper. And so like my calendar is full of half a dozen deadlines every single day, documents, papers, all that kind of stuff. So you want to make sure you're on the same page as your attorney, that they're getting it filed. I routinely will file a motion on the day that it's due. I'll file an answer on the day that it's due, which makes people nervous who are not attorneys and not working in the legal world, just because, you're like, oh, we better get it filed a few days early. Most attorneys are working on so many deadlines that we have these running deadlines that, it's all drafted, ready to go. And then the runner sends it out and we get it filed. So I would just communicate with your attorney, make sure you're on the same page as them to make sure that it gets timely filed. One other question from the comments said, does a bankruptcy trustee look at your bank account record in the bankruptcy process? So every bankruptcy, whether it's Chapter 7 or Chapter 13, you're going to have a bankruptcy trustee assigned to your case. The bankruptcy trustee works for the Department of Justice, and their job is to really administer your case, see if there's any assets that can be sold for the benefit of your creditors, and then distribute any proceeds, if there are any, to your creditors. So the question is, are they going to look at your bank record? Yes. I can tell you in Arizona, they request usually 3 to 6 months of bank statements from before you're filing. And they go through that. What they're looking for, I get a lot of clients who say, oh, they're going to see that I'm eating out too much, or I bought, whatever. Really what they're looking for is large purchases or big, cash in, cash out kind of things. They're looking to see, okay, you got deposited money that wasn't your paycheck. Where did it come from? Or you had a $3,500 withdrawal that's really out of the ordinary. Where did that money go? Those are the types of things they're looking for. They don't care how many times you went to Starbucks or whatever. They don't care. So that's really what they're looking for, that kind of thing. But yes, so and I should say this, you need to be prepared. If you were going to file a Chapter 7 bankruptcy, everything's going to be laid out on the table. There's no secrets with you and your attorney. There's no secrets with the trustee. The trade-off of getting the bankruptcy discharge, which is super powerful. I mean, that's getting rid of all that debt. In most cases, there's no repayments, anything like that, that you have to do. But the trade-off is you got to be an open book. And to fail to disclose information in a bankruptcy is actually a felony. And do they prosecute it? Yeah, they do. All you have to do is watch all those Real Housewives of Phoenix or whatever shows. For whatever reason, all these reality TV people, they just get nailed they file bankruptcy and they don't disclose things. I always tell clients, look, 1 million people in the United States file bankruptcy every single year. This is not their first rodeo. They know exactly what's going on there, and they know where to look for it. Even like with crypto, I know that when cryptocurrency got really big, people are like, oh, you don't have to disclose that. If you go look at the major crypto wallets, most of them on their website even have a form for bankruptcy trustees to fill out where they will assist them in doing a search of those to be able to disclose it. So, okay. I think this is a different question. I thought this was a bankruptcy question as well. Can they force their way into your house? In bankruptcy, no, they can't. So, all right. So, yeah, but it's unlikely. But this is a good question. I'll go back up here. So, let's see right here. There's a couple other questions. I'll jump in first. Derek says, weeks after filing a motion to compel arbitration is Midland, still haven't heard anything. Any response? Relax or take action. So, I would say that it is something where it takes more time than you think. So in most jurisdictions, they're going to have anywhere from like 10 to 14 days to respond to your motion. So you file your response with the court, your motion with the court. You've got to send a copy to the attorney on the other side. The courts typically don't do that. So you need to make sure you did that correctly. And then there's a timeline where the court has to let it go by before they can rule on it. So in Arizona, it's usually 10 business days, plus they give them additional 5 mailing days. And so all of that's got to go by. You can call the clerk of the court and say, hey, when is the response due on that? Because they calendar it. And if the time hasn't expired yet, then you can relax. If the time has expired for the other side to respond and they haven't done anything, especially if it's been a few weeks, you could call the clerk and just ask him, is the judge going to rule on that soon? And if you don't get anything in an extended period of time, you can even file a motion and ask for what's called summary disposition. So, all right, let's see here. Stacy says, how can I file without my spouse filing? I'm assuming this is a bankruptcy question. So married couples do not have to file bankruptcy together. They can file bankruptcy together in a joint case, but if they don't file together, the only thing is there can be certain risks in certain jurisdictions, particularly places like Arizona that are community property states where most assets and debts are considered joint. It is possible that a non-filing spouse, if your spouse doesn't file with you, that you could be in a situation where a creditor could go after a spouse, down the road after the discharge has been entered. So that's something that you've got to be careful of. As far as that's something to talk to an attorney about for sure. But I can tell you that routinely attorneys file for one spouse all the time. So, all right. Dustin said, I live in Arizona. I'm married, but filing a Chapter 7 for myself. How far back do they go to check out me and my wife's income? She was out of work for several months, but working now. So in determining if you qualify for a Chapter 7, they're going to look back over the last 6 months prior to the filing of your case. For means test purposes, for determining what you qualify for, they do not count the month that you file your case in. So, for example, I'm recording this on February 1st of 2024. It's my daughter's birthday today. Happy birthday. They're going to look back. So cases I'm filing in February of 2024, they're going to go back 6 months, and they're looking January 31st, and they're going to go back 6 months from there. So it's not something they don't count the month that you're filing in. So I guess what I'm trying to say. So that's the time period that you're looking at to getting it squared away. So, all right, let's see here. All right, we'll do this one here. It says, what other letter do I file besides a compel for arbitration letter? Do I ask the other side to start the process? So, the first thing you're going to do if you've been sued, usually you file an answer. You're going to want to file something to make sure that there's no default that gets entered against you in the court. If you decide you want to try to push the matter out into private arbitration, first you have to make sure that the contract with the original creditor has an arbitration clause. Often they'll attach the terms and conditions to the complaint. If they don't, you can file an answer, and then in the disclosure process, they should provide that. And if they still don't have it, if you go over to the Consumer Financial Protection Bureau's website, they have a place where terms and conditions for all kinds of credit cards are there, and you can look to see if they have the terms and conditions for your card, and if it has that arbitration clause in it. If the court grants it, then usually what the courts will do, sometimes they'll dismiss the case and then say, okay, go ahead and do it. Often they'll say, we'll give you 90 days to initiate it. even if you're the consumer, I recommend initiating it. Don't wait around for the creditor to do it. Go ahead, file it. There's a filing fee that's associated with that. That's a couple $100. You're going to have to get that squared away there. So that's the way that I typically recommend is I use, and if you've been on the channel for a long time, I used to say, you know what, wait around for them to file it, but I don't think that there's really overall a great thing, benefit to doing that. Just go ahead and get a file. So, all right, I think we'll close it out tonight. Hey, good evening. First time listening live stream. Awesome. And happy birthday, my daughter. Thank you. And actually, I better run because it's her birthday, and I better give her a call. Make sure her dad gets in touch with her today. But hey, I appreciate everybody checking us out tonight. If you, again, check the links for the links to Solo Suit, the Consumer Warrior University, a lot of other templates and resources there. And we will take it from there and catch you next week.